hearing day number one for hearing stream number 3 dealing with the rural zone. This morning we heard from the Section 42A officer, Mr. Charles Horrell, and his technical expert, Ms. Chambers. Horrell's finished his presentation and has some homework to report on. And we're now going to move to submitters. But just before we do, Mr. Horrell, the panel would like to add to your homework. We'd like actual presentation of all the exemptions to the 40-hectare rule and all the parameters for establishing lifestyle subdivision activity in the rural zone to be presented as part of your right of reply, just so that we have that as a sort of a cheat sheet, if you like, part of our deliberations. So things like how the surplus dwelling rule works, how balanced allotments work if you're creating a understood allotment, that sort of thing. That makes sense to you?
Yes, that does. Yes.
Purely factual. We don't need any evaluation, but just a list of all the parameters for departing from minimum 40-hectare rule in the rural zone and the minimum standards for lifestyle development of the rural lifestyle.
Yes.
Yeah. Thank you. Well, welcome, Mr. Aburn, and your clients. So you're presenting on behalf of the Wairarapa Wine Growers Association, Martha Holdings, and the Aburn Popova Trust.
That's correct, Chair. Excuse me. Firstly, to say thank you. I don't usually appear in front of a panel of 9. I apologise if I don't directly eye contact with you all individually. I'll be focusing more on the front.
What I can say, Mr. David, this is the first time I've appeared in a panel with 9.
And secondly, although I might act as ringmaster, I don't have a big whip, so I can't control my people. Of course I can. Look, can I just take your leave and say, in addition to the 3 listed here in the speaking notes, also Porter's Pinot, and we would like to focus in the hour we've got over those 4 submissions, primarily on Wine Association and Martha Holdings. That's because little has been said, certainly in the 42A report or in the further supplement today about Vintners Lane, about the overlay there, which we're seeking to retain. So I assume that's not there for at risk, as I could put it that way. So look, just to introduce my colleagues, my immediate right is Dr. Derek Milne, scientist, appearing on behalf of Martha Holdings Limited, provided a statement of evidence. Wilco Lamb, Chair of Wine Growers Association, Wine Growers Association, again, statement of evidence, and Mr. John Porter, Director of Martha Holdings Limited and also of Porter's Pinot.
Yes. Welcome, all 3.
So look, I think we'll start with Wine Growers Association, and as you'll be aware,
yes, we have a statement from you, summary statement.
Yeah, just a speaking notes. And that's because I know when I'm sitting on the transmission, I cannot always take notes when I'm listening to the speakers. So I've tried to put those in front of you, and I'll email them to your team later on.
Good.
The association, as you'll see from the evidence, is generally supportive of the provisions that relate to viticulture, and particularly in the Martinborough area, and that therefore includes the Martinborough Soils overlay, and also supportive of the proposed new definition for horticulture, which includes specific reference to viticulture or vineyards. The reason for that submission was that there was some objection policy that did refer to specifically to viticulture, but others were silent. We thought, to be consistent, they should all refer to viticulture where appropriate, but the approach adopted by the officer is that we can include a new definition of horticulture and therefore vineyards. So we don't take that further.
And that'll do the heavy lifting, presumably. That'll do the heavy lifting.
Yes, exactly.
But both effective and efficient.
Yes, I disagree with that, Chair. So look, the 2 issues, visitor accommodation and minimum lot size. And I'll ask Mr. Lamb to sort of put forward the association's perspective on those 2 matters first, and then I might provide some expert evidence to follow up. So just,
Thank you, Alistair. It's the first time I actually appear in front of a committee, so I'm not really sure where to start and how to go forward. But I think on behalf of the Wellington Wine Growers Association, thank you for having us here to further some of the issues. The first one was visitor accommodation, and yeah, I think we won't strongly oppose that, Alistair. I think there is provision around resource consents that would probably, will give people enough sort of opposition from our perspective to sort of develop or to have some sort of say in terms of how to further that. So,
I think the point there, Chair and Commissioners, was that initially, because of the very strong policy direction to protect the soils suitable for viticulture that are covered by the Martha Soils Overlay, even though the association said in its submission they have a close synergy between the wine industry and visitor accommodation, and that's clearly evident, with the Martinborough success. They didn't want to, my words now, penalise visitor accommodation, but they felt it would be more appropriate to sort of emphasise the protection of those soils, and therefore for visitor accommodation to look for sites still within the general rural area, but outside the Martinborough Soils Overlay, and felt that therefore with that strong policy direction, non-complying activity status could be appropriate. I see Mr. Hurrell's recommendation about it being discretionary, and yes, I accept discretionary activity can be appropriate. Of course, those that have gone back into history of resource management and town planning have the understanding that discretionary means it can be appropriate in the zone, but not necessarily on every site. So that's where the focus comes. And so all we're saying is consideration could be given the strong policy direction to identifying the accommodation as non-complying. But as Mr. Lamb has just said, I'm not going to die in a ditch over that. If it's discretionary, so be it. That still gives rise. And I note, and I think I'm correct here, but I'm happy to be corrected, but I don't think there's any of the various rules in the combined district plan that have the exclusion or preclusion from notification procedures, as a number of district plans now do. And so that opens up the uncertainty of it all, because it will be the application could well be notified, but might not be notified. And so that's just a wee bit of a risk around the discretionary activity status. But I endorse what Mr. Lamb has just said. We're not taking that as a strong point going forward. But in terms of minimum lot size,
yeah, I think we have a very strong opinion on that, to be really honest. Originating from the Netherlands, where I think we have got quite a strong history of trying to protect anything that we think culturally and agriculturally is worthwhile protecting. Here, I see a similar issue at hand, really, where there is some real danger being overtaken, by maybe 40-hectare lot sizes competitive standing for minimum hectare minimum lot sizes by sort of agricultural, large scale agriculture, really, that sort of will really damage some of Martinborough's current feel, what the whole Martinborough industry, what viticulture industry is built upon, is pretty much sort of 4 or sometimes even smaller lot sizes, where we can have families actually making a living from a small sort of vineyard and perhaps a cellar. We just don't really see where suddenly a tenfold of a minimum size would come from, and how that would then open up opportunity for people to be able to sort of start a wine business under that sort of ruling, where very sort of strongly, I think it is visible that smaller lot sizes can be economically viable for people. Yeah, I think 40 hectares, it's not so much sort of, it says here 65% of the existing vineyards are smaller than 5 hectares. I would actually look at it in the other way, is how many lot sizes are 40 hectares or over in Martinborough or the region, or maybe even further afield in other areas in New Zealand where there's viticulture, I think 40 hectares is quite excessive, really.
Thank you. I'd just like to refer to my speaking notes on page 2 under the heading 1.2 minimum lot size, and just these 4 paragraphs I will read. Martinborough's character and economic well-being is significantly dependent on the viticulture industry. As the 42A report notes, of the existing vineyards in the Wairarapa, the majority of which are in the Martinborough area, are less than 5 hectares in size. 65% are less than 5 hectares. They contribute significantly to the viability of the local wine industry. 40 hectares is simply too large for these, what I refer to as boutique vineyards. Why put a future viticulturist seeking to establish a boutique vineyard in the Martinborough soils overlay through the time, cost and uncertainty of a resource consent application when all that such future boutique vineyards will be doing is adding to the character of Martinborough's wine industry? Mr. Horrell's concern is that the 4 hectare minimum would pose a significant risk for further inappropriate subdivision. Question: is the existing pattern of established small-scale vineyards in the Martinborough soils overlay inappropriate? Does the established pattern detract from the character of Martinborough and its wine industry? Given the specific policy direction of protecting the MO soils from viticulture, in my opinion, that is justification for establishing a minimum lot size within the MSO. And as you know, it's a fairly limited area, the MSO, that is supportive of the establishment of vineyards, both large and small. Existing character is dependent on small vineyards. 40 hectares, can we visualise 40 hectares? If anyone knows the Clouston Vineyard, Palliser, at the end of Weld Street and fronts onto Vintners Lane, there's a popular public walkway through there. How many hectares do you believe that vineyard is?
You tell us.
35. So today it would have to apply for resource consent to establish. And is that a nonsense? I'm not going to use the word, but that's just establishing. That's the largest vineyard in Martinborough. On Giant Shoulders, with Mr. Lamb here is very familiar with, is 4.9 hectares on Giant Shoulders on Princess Street. So the pattern is smaller vineyards through to large vineyards, but still less than 40 hectares. So please use the existing provisions, 4 hectares. I did hear the comment this morning that maybe move from controlled to restricted discretionary. Yes, but only if there's very clear direction that that's for vineyards and without having a residence associated with it. So that's the submission on behalf of the wine growers in respect to those 2 matters.
I'm very supportive of that. If there is sort of a 4 hectare lot where we need not to be able to build, a house on it, I think to keep that as sole viticulture or horticulture, that would be our recommendation as well.
So can you just clarify that, Mr. Lamb, that last statement there?
So if the minimum lot size is 4 hectares, then we would support sort of the to restrict that to not, so you can't build a house on it.
That would be subdivision only, not allowing for a dwelling.
Correct.
Residential.
Yeah, because then you take more and more of 4 hectares is probably the minimum size, really.
We might move to some questions, Mr. Abraham, but just before I do, can I just, when you talk about establishing a vineyard, the 40 hectare rule relates to subdivision as opposed to the land use. So presumably a vineyard could establish without going through subdivision on a larger allotment or even a smaller allotment. It would only be where subdivision was involved that the discretionary activity rule would be triggered.
Yeah, I guess the point here, Chair, is that it's anticipated that future yards will not require 40 hectares and therefore have to go through the time, cost and uncertainty of a subdivision consent.
Yes.
And therefore, if the pattern, long-standing pattern is of smaller vineyards That's the character of the Mark Resource overlay. Why not allow that to continue in the future?
Excuse me, and your 1, 2, 3, fourth paragraph on your speaking notes. About the cost and uncertainty of a resource consent. Are we talking about the need for a resource consent, or are we talking about the activity status of that resource consent? Because all subdivision will require a resource consent of some sort.
Yeah, discretionary activity, and because there's no preclusion, there's the possibility, I can't say how strong that possibility of that going through some form of notification, which opens up the uncertainty. That may not be the case for controlled activity subdivisions or even RDAs.
Yeah, and we're not talking about, you're not talking about a permitted activity for a subdivision. No, you're talking about either controlled or RDA.
Correct.
Yes. Okay. Panel, any further questions of Mr. Lamb or Mr. Avery?
Yes, just on your comment on 4 hectare lot, you wouldn't require, or you're not suggesting they put a house on it, but what about a pack shed, work shed?
Yeah, I'd say some people would definitely need a tractor shed.
Yes.
On the property, yes.
Point. Thank you.
Alistair, then we'll go Robin.
Yeah, thank you all for turning up. And Stephen, I just want to examine the subdivision size, but taking into account, Mr. Lamb, your comment about no house on it. A lot of the history of Martinborough was, as you rightly point out, small boutique vineyards and wineries setting up, and Orders is a prime example of one of those that actually had a vineyard and his own winery. So when you talk 4 hectares and then saying you can't put a house or a structure on it, is there somewhere, and you've heard the officer say 40 hectares and the risk that goes there, and you're arguing 4, is there somewhere in the middle here that you would see is actually a practical size that would enable what you're talking about in terms of the establishment of a vineyard and or winery, that could reduce that risk that the officers have identified? So obviously the risk was it could be used for purposes other than viticulture. So where's the compromise position that you guys, as the experts, would sort of see would be that we could consider would be a compromise solution to this? So obviously we're miles apart in your view and the officer's view. What's a compromise position that actually meets those requirements as you've talked about with boutiqueness and retaining the character of Martinborough?
Coming to me, it seems. But look, I was listening this morning to the helpful discussion between the committee and Mr. Harold, and I mean, if it is a concern that controlled activity status puts at risk the Martin Resource overlay through inappropriate subdivision, maybe, and it's not raised in our submission, and I don't know about the question of scope, but if it was an RDA and then very tight matters over which discretion is retained, that it be used for viticulture, etc. And if that's the case, and if there's a preclusion from notification, and why do I hammer that? It's all about the uncertainty that goes with notified applications. Maybe if that's the case in RDA, it might be 10 hectares. But I would like to suggest that even 10 hectares is too large for the majority of vineyards. But if it was a controlled activity or RDA and specific reference to the purpose of the subdivision being to encourage, enable, and it's interesting that Mr. Harold uses the word, it does not enable. The 40 hectares does not enable viticulture. It's disenabling. And so it's always difficult when it's sort of on the hoof a wee bit. And if this is a matter for further discussion.
Perhaps not, don't give us an answer today then, but have a think about it and perhaps speak to our officers. And
yeah, I'm aware that
something that might meet the requirements that you guys have got, that then meets that protection issue that we're talking about and the highly productive lands. You know, somewhere in the middle here is a compromise.
Yeah, I mean, absolutely, Commissioner, if the panel was to direct there be some expert conferencing on this, I would welcome that.
Right.
I think we can come to a solution. The reason I say that is because I firmly believe that no one in this room wants to see an undermining of the character and amenity of Martinborough and the soils overlay, which has established over the last 30 years and is regarded internationally. And so we must ensure that the future provisions enable that pattern to continue.
Basically, that you-
Yes. Yes, the questions of Mr. Abern on that.
Yes.
So somebody else wants to comment?
You want to make
Dr. Mel would just like to make a comment.
Chair, I'm a bit hesitant to come into this because it's not strictly my role with respect to the evidence, but if we came at it from the point of view that Martinborough has developed from an absolute non-entity when I, as a young fellow, started planting grapes to now become a weekend playground for Wellington, and the charm of it is to go through this little village and these many little vineyards with some pretty funky people and some very nice wines, etc., as well as developing an international reputation. It's the rather fragmented little charming rural character which attracts many people. The issue about lot size, I think, will get determined, is being determined now by the economics of it. Some people may start a vineyard and then need to sell their grapes to an existing winery, so long as they make a good living and they can have a bottle with their own little label on it, etc. There's a variety of ways in which these are done. I think that the community would be wise to not limit the scope for variety, etc., etc. The issue about housing on the 4 hectare lots, and this is just speaking from being an old man who's looked at it for a long time, land is of course used as a first order financial security and it's very valuable if it's subdivided, etc., etc., etc. But if the vineyards are put in, they're a long-term investment in their own right. If a small lot then has houses within it and adjoining it, etc., there are the added risks of things like noise, bird scaring, spray risk, etc., etc., etc. The question asked before about sheds, etc., these are part of the industry and they are not filled with householders, some of whom may have little babies who are likely to get upset about this type of thing. That's part of the industry you're living in. But the moment too many houses start coming around, there is the risk of, as we know throughout New Zealand, of people complaining, oh, we didn't realise that this was what these people do in these vineyards, etc. So I am supportive of trying to keep the housing within the village. Now, if I might expand for a moment longer, places like Burgundy, where Pinot Noir, of course, the home, many of those big vineyards, as I understand it, they are actually consistent of tiny little parcels of separate ownership, all amalgamated into one vineyard, sometimes because of families and little family shares. But the workers, etc., live in the little villages. And it is again my understanding that there are pretty strict rules about allowing urban development out around the vineyards itself. The French haven't done this for nothing, and I would suggest that part of the reason why they've done it is for the reasons I've expanded on. Thank you, Chair.
Thank you. Unless there's any other question,
I
but
did have-
sorry, Robin.
It's okay. You said that Palliser was the single largest one at 35 hectares. What would be the second largest, just to give us an idea?
Probably be on the Martinborough Terrace would be currently Lunar Estate, I think at 18.
18, yeah. And then from that,
Maybe some of Foley's families would sit around about a 15.
thank you.
We would like to direct some conferencing, Mr. Abern. Mr. Horrell's already indicated that he's got an appetite for that.
Excellent.
And we probably will produce a minute to outline what it is, but if you don't mind, I'd like to just verbalise what might be in that minute and to provide some real time sort of guidance of that assistance. The starting point for the panel is the strategic direction, which is to avoid fragmentation in the rural zone, fragmentation of allotments. Without nailing ourselves to the cross, the panel do have some doubts about the 40 hectare rule in relation to viticulture, based on the evidence we've heard to date. So we need to balance that against the strategic direction. And it seems to me that there's two questions that need to be answered. If there's to be a specific subdivision standard relating to viticulture, the question is, what should the metric of that be? Obviously, it needs to be more than 4 hectares. And Mr. David, you've mentioned perhaps an outlier of 10 hectares. It needs to be justifiable and not arbitrary. So that's the challenge for you and Mr. Horrell to settle on that. The second is, what should the activity status be to align with that? And the Horrell's been quite clear that it should be something greater than controlled activity to enable the council to decline it. And I think, David, you've sort of echoed those thoughts also. Those aren't small issues, but they'll probably have answers to them. The third question, if you like, is what else needs to be put in place in the rule framework to prevent incompatible land uses such as livestock allotments establishing? And David, you've said that that might be able to be covered off by a matter of discretion. What I'd like, whilst that's an option for you and Mr. Horrell to investigate, I'd like to also see that matter being a precondition to being a restricted discretionary activity, so that if you didn't meet that, you could take that avenue and you'd go to the higher status of DA or whatever. That might be a more efficient way of dealing with the matter, but I'll leave that to you. But that's the sort of thinking of the panel. We had the benefit of discussing this in the lunch adjournment, and we wanted to explore those options. So my question to you is that reasonably clear direction for?
Yes, it is, but I'm sure it'll be made even equally clear in a minute. But thank you.
Good. We gave a lot of direction in hearing stream 2, Mr. Abraham, for conferencing, and probably 7 or 9 directions, and almost without exception there was resolution. So we're very hopeful.
Thank you.
Speaking, I haven't missed anything.
No, I think
That's the first evidence.
If we can now move to Martinborough Holdings Limited, and so David's been Dr. Bill and myself, perhaps Mr. Porter will kick it off.
Here today and let past the fact that I've been a solicitor for nearly 50 years. I think I've been in every court of the land, from the old magistrates court right up to the Supreme Court, all the ones in the middle, and I've never appeared in front of nine. So it's a
first time for everything.
And to tell us that don't quite know where to look, but I'll give it a go. Now, I'll just summarise my evidence very briefly, if I may. At Nelson's Road property has had a commercial industrial use now for some 70 years or more, I think. There's no prospect of ever reverting to agricultural or true rural use. I think Mr. Horrell kindly accepts that. And what's more, as you've seen, the soils that are there now and under the buildings and the bare land, they're new soils. They've been brought in there. A lot of them have. So in short, the soils overlay not required on that site. It benefits, gives no benefit. And you've also seen the evidence of Dr. Milne. And he drew the very map we're all here today talking about. He's the guru. He wrote the Bible. And he says that when he did the map, it was a broad brush, it wasn't detailed. And agrees that there are some sites included in the overlay that should not have been. And also, he goes on to say certain sites do not warrant the overlay protection, and Nelson's Road is one such. Simple as that. Now, I must admit to being somewhat puzzled when Mr. Horrell says that Nelson Road should stay as is with the soils overlay as a buffer zone. And I wondered to myself, a buffer to what? Why? I'm not quite sure that a buffer zone is detailed anywhere or identified in any of this planning legislation that we're dealing with. And I say two things. I'm not sure whether it's a physical buffer zone, so that you walk down the road and you see, oh, this is a buffer zone. Mr. Horrell is referring to a sort of an ideological concept like Christianity, say, you know, you can't see it, but apparently it's out there. So I'm not quite sure what Mr. Horrell wanted, but if it is a physical buffer zone, then that will still be in place, because on 3 sides of our Nelson's Road property, there's about a hectare full of huge logs which are cut up into firewood 6 days a week and fed into the Wellington market. That's on the eastern side. And to the north is the spray painter, panel beater fellow. And to the left, to the west, there's a practice yard with diggers and all that sort of thing. And they haven't applied to have the overlay removed because it doesn't worry them. So that physical buffer will still be there if that's what it is that is causing the problem. So I just make that point. And that's probably, you've seen the evidence. I just like to say one other thing that's, I want to tell you how to suck eggs, although that's what lawyers do to judges all the time, and I suppose I'm trying to do a little bit. Know what I mean? You see, you're here because every 10 years we get a chance to look at the planning legislation and review it, see if it's fit for purpose. And a lot of people spend a lot of time, money and effort to make these submissions and seek a better way, what we're doing here today. And you spend a lot of your time and effort and get paid a little, I think, to make the decisions. And what I'd really like to encourage you to do is be proactive. Don't just kick the touch, because, and that's what you're being encouraged to do by Mr. Horrell, and I see where he's coming from. Don't just maintain the status quo. Please look at what we're asking for here. If there's one site in that overlay that does not deserve that protection or want it, it's Nelson's Road. No, there couldn't be a better site. Come to you here and say, please take it away, because leaving it there prevents development for what it should be, which is little people want to put up a warehouse or for whatever reason, and there's not land for that in Martinborough at the moment. So I do encourage you to be bold and just review it as you have the power to do. But if you were going to even think about declining that application, could you please adjourn that decision off to the change of use hearing, which is not until April, sadly, when we try to change the zoning. So in a nutshell, what I'm asking you to do is exercise your judicial function and give us what we want. And if that sounds very greedy, but it's common sense. But if you were wanting to decline, please don't do that either. Then you can kick the touch. You know what I mean?
let's just see if there's, maybe did you want to add anything before we went to questions?
I'd just like to highlight 4 points. In the first, Mr. Chair, the knowledge that your background is in planning, I'm going to use the word fanciful. I think it's fanciful to think that this site will be developed for any high cropping, including viticulture. And I think Mr. Hurrell accepts that. Now, he doesn't use the word fanciful, but panel, the reason I use that term, it does have some meaning in RMA language. It is absolutely fanciful to think this site will be utilised for viticulture or other high cropping in the future, because half of it's covered by significant buildings that do provide a really important service to Martinborough. It was one of the largest storages of wine there, so it's contributing to the economic welfare of Martinborough. And secondly, it is highly contaminated, but the original soils have been largely removed. And the substrate is also contaminated, so there will never be crops on that land. That's the first point. The second point, and I hesitate to make this point because I made it in my evidence in chief, but the map that you saw on the highlight this morning is incorrect. It only highlights the area covered by the buildings. So the area along 3 is the full Nelson's Roads. And it may be a bit of a double-edged sword when you start to wear buffers, because it's now a larger area than what was shown in that figure. But that is 10 Nelson's Road as defined in the submission put forward by
Can we bring that image up again, please? Okay.
3.7 hectares.
2.71.
It's just a square, wasn't it? On the,
oh, that's not.
That's it.
And so the yellow highlight was just on the square portion.
Yep.
And this goes right through to the river, the lot. And so is why I say a double-edged sword, it comes back to this issue of what is a buffer zone in this situation, and what is a buffer zone seeking to protect? Because buffer, you try to protect from something, don't you? You separate out, etc. And you have to look at the established pattern here, not only of Martinborough Holdings, but of ACE Panel 8 and the log storage. And so I think if there's any site anywhere within the Martinborough soils overlay that justifies being excluded from that, it's this site. And so I leave that.
Just to clarify, Mr. Adrian, the area in red or dark pink, that's on.
Correct.
Okay, that's the area, not just
The full site that's been referred to in the evidence as 10 Nelson's Road.
sorry, a question. So the lot DP 89165, just below it
to the south.
to the south, my north, south, east and west is really dodgy, so excuse me. And then up off to the right, east, 411892.
Yes.
Are these sites, two of the sites that you've referred to being the panel and paint and
Correct.
logging or?
If you like, I could show you on the map.
But yeah, please, thank you.
I can navigate this minefield here.
Oh yeah, watch out for the trip hazards.
Right, the Nelson's Road site we're talking about is this,
Yes.
Yeah.
all of this,
Mhm.
right? That is a huge big timber yard. And those are all logs. Those are huge piles of logs. And there's a big machine here that cuts one log into about 30 bits all at once, you know. So that's the timber yard on the right. That's not us. That's Ace Panel and Paint, but what he does, and down here is the contractor's yard. That's all diggers and that funny bit down there, that's a road that's never been formed. That's the Nelson's Road extension. So there, that's
Just stay there for a minute. The northern parcel.
like the north about there.
Yes, sorry, it was the rectangular parcel that
Just further down. Oh.
that runs parallel to the unformed road.
Yep, top.
This, but
Yeah, keep going. And this parcel the parcel below that, this entire parcel there.
Yep.
What's that currently occupied by?
that's bare land.
And is that the land that's contaminated?
All parts of the land here and there are contaminated. There's a bit there, a bit there, a bit there.
Yeah, okay. How long has it?
Chair, I could.
How long has that been vacant?
I
What was its former use?
Just forever. It used to be a timber yard, as in when it was,
Okay.
when it wasn't going to be open, storage yards.
The one lot, isn't it?
That's what led to contamination, because they would treat the
Posts, yeah.
timber as opposed to whatever, it's the building timber with chrome arsenate.
There's obviously some residual,
Mr. Bill knows all about this because, that's
So
better.
that's all part of the same site though.
It's all the same.
It's all the same site.
It's 2.7 hectares of
Is-
this.
Okay, and that's what we're referring to as
That
10.
should go to there.
it does.
It does on here.
Mm.
And so just whilst you're up there, the bottom square,
See it,
next one down, that isn't in colour.
this one here.
Just get in there. What's,
That's a house.
That's a house.
that's, okay, it's residential, okay. A house, thank you.
I could help with that northern bit. It's been extensively recontoured, etc. Was used as a huge dumping ground for all sorts of rubbish. And it actually fell away towards the lake there quite markedly. And I don't know how long ago it was, but maybe a decade or so ago, I don't know, John, it was all pushed around and re-leveled, but it's basically a bit of a mess underneath.
Yes. Thank you for that. Thank you, Mr. Horrell.
Mind the wise.
You were going to update that plan because there was a property missed off there also. If you could update it for the correct boundaries of the Nelson Road property, that would be useful too. And you're right.
Can I just ask a question? Has there been a recent soil test done on that land?
Yes, yes. it has. And it's, the contamination is not nearly as bad as it was,
But
but it's contaminated.
yes,
And,
the main contamination, I suspect, would be arsenic, is that right?
and chromium, I think.
Mm.
So what would be required? This might sound like an obvious question to you, but what would be required to make that land fit for viticulture? bringing in truckloads of fertile soil.
You can't even grow, it won't even grow trees.
Right.
They're all stunted and twisted and.
Yep.
You couldn't do it.
Okay. I said it was an obvious question.
Suppose they built the Great Wall of China. Probably couldn't do that today. But
You have to dig very deep.
imagine that.
Here, I think the essential thing for grapes, with crops like that, is that the whole block needs to ripen at the same time and the plants to perform evenly. If I were purchasing that land, I wouldn't touch it with a barge pole. Martin Vineyards, when I was a director, we did buy the piece of land, lot 2 DP 434480, part of the old Carter Holt land.
Mhm.
We extensively tested the soils. It was just used to finally dry timber after it had drained its copper chrome arsenate, dry it out in the open. We very carefully tested the land and we did find it was acceptable, but the land was of an even soil condition still. It had simply had stacks of timber on top of it. So we felt it was worth the risk. But this bit, I wouldn't touch it with a barge pole.
And the other point, of course, we've got a lot of very expensive buildings. Would be very expensive to replace. Pepper potted throughout the site, apart from that vacant land. And it's totally unrealistic to think they will ever be pulled down and turned into an agricultural use. And what's more, where would we put 500,000 bottles of our beautiful wine? Not my wine, your wine and other people's wines, which is stored there. So it will always be commercial.
I think
Yeah, I've got a couple of questions for you, and you opened the door on my second. I'll come back. When we removed the overlay, I asked Mr. Hutt for what would happen, and it would revert back to general rural zone. So what do you achieve by removing the overlay? What do you feel you're going to achieve if we said, yeah, we'll remove that?
Mr. Aburn's the planner, but I'll tell you in a nutshell. It's so much easier to change the zoning, which we've also made an application to change it to the mixed use zone, which would permit subdivision and buildings as of right, as in commercial buildings, and Alistair will say it's so much better.
Because that was the second question I was going to ask.
Well, on that, sorry,
Change. So try and
on that point, as I note at the bottom of my page 3, the submission did cover the 2 points: remove mud and soils overlay and rezone the property from general to mixed use. And the way the panel was set up to hear the rezoning in May means that matter can't be addressed now. But in my opinion, the two are quite closely interrelated. And at the top of page 4 of the speaking notes, I do make the request that if the panel was thinking of retaining the Martha soils overlay, please hold that decision over until such time we appear in May in terms of the rezoning, because your point, Commissioner Plimmer, is a very good one, that it's not just a case of removing the overlay and then developing it for rural purposes. This site, given its history for commercial purposes, etc., seems to be the way forward. And we're going to have that discussion when we appear in May on the rezoning request.
Mr. Owen, I can give you every assurance that the panel won't be making any decisions in isolation.
I did pick that up this morning when you talked about the.
The decisions will be at least at the same time.
Thank you for that confirmation.
But it does raise the issue of the relationship between the request to remove the overlay and the request to rezone the property. Are the two requests relating to exactly the same boundaries?
Correct.
And given the confusion that that existed with the delineation of the site on the map that Mr. Hull used, are we clear that the full legal description was used in the relief sought?
Absolutely, it is in the submission.
Good. If you understand why he does that.
Absolutely understand.
Yeah. Goes to scope, and I just didn't want to go down a rabbit hole if scope wasn't there. You would encourage us to make a decision or make a finding based on both requests, presumably in conjunction with each other, not in isolation. Or was it a stepped approach? I mean, if we...
Well, it could be stepped, but I guess it comes back to that section 103, which you'll be very familiar with, that where there are several matters relating to the same, let's consider them together. Simple as that. And I think this is about a property, 10 Nelson's Road, as defined on that aerial. We believe the overlay should be uplifted and enable development to occur under new zoning, which we will address in May.
Certainly, and from a very hypothetical basis, given that we have no basis to even consider the zoning request yet, if the panel hypothetically was of a view to remove the overlay but not to change the zoning, what would that, where would that leave your client in terms of the question that Councillor Plummer put to you about what's actually gained from that, bearing in mind Mr. Horrell's answer this morning that the activity status remains the same?
Well, we would be able to at least look at other activities under the rural zoning that are not viticultural high cropping, because the protection of that land for viticulture, etc., is gone. If the MSO is gone.
And the policies relating to that are gone. Yes. So even as a fully discretionary, you've got less of a policy variance.
Correct.
Okay. That's very clear. Just make some notes about that. Now, if you don't mind, I just want to go back to the very first matter with your first grouping of clients, as in terms of the directions. I omitted to mention something. In the conferencing, one of the things that you and Mr. Horrell will look at it would be an alternative rule framework for subdivision. When you do that, would you also have considerations to matters, any additional definitions that might be needed, bearing in mind that you've already supported the definition of horticulture. That, and secondly, whether there needs to be any change to the policy framework. It's a little bit, so I guess that's a bottom-up approach, Mr. Abraham, from making sure that that if there are rule changes, that they are reflected in the policy, or if not, there's a change to the policy. At the moment, the policy is determining the rules, the top-down approach.
Yeah, that's a good point. And I was sort of thinking about one of the design use the phrase avoid, and you were inquiring as to where that word is used. I guess I was using it because to protect, to me, means to avoid. And so I was taking that sort of lead in terms of using.
I was looking at it quite literally because it appears in P4 in terms of subdivision.
Yeah.
But in P8 and P7, it's not quite, the word's not used.
No, but
alternative words are used.
yeah. But look, thank you. I've taken some notes and look forward to seeing the minute. Thank you.
I think that's everything from me. I'll keep the minute fairly brief because
Understand.
we've had this ability to discuss it.
Yep.
And it probably won't be until the end of the week that I get that out.
That's good. So look, I think therefore we could move on to the final submission
For the trust.
Abraham October Trust and also Porter's Peanut. We could just look at those two together because they're effectively addressing the same. But in advance, I want to make a small personal statement. The Abraham Popover Trust, I am a trustee, I'm a qualified planner. I've confirmed that I'm producing evidence on behalf of the trust in a code of conduct. And that leads me to the second point. In the 42A report, and again in the statement this morning from Mr. Hurrell, he said that the Wairarapa's wine growers, Martinborough Holdings, and the Abraham Popover Trust all supported the submissions in terms of visitor accommodation and allotment size. It's incorrect. It was only the Wine Growers Association. I guess it goes back to the fact your minute number 2 required I produce a single statement of evidence. And I did.
Yes.
I had 3 clear sections. So now in terms of Abraham Popover Trust, the only matter is about the MSO applying to Vintners Lane. And we particularly wanted to reinforce that point today because we are aware there is a submission in front of you. I understand they're not attending, given no evidence from Antilles. It seeks to change the zoning of Vintners Lane in addition to removing the MSO. And from my point of view, and it'll be reinforced more strongly by Mr. Porter, is clearly established vineyards in Vintners Lane, including my 1.8 hectare lot. And we make a very good drop of Pinot Noir, and I haven't got any bottles here today, but seriously, it's a very successful little vineyard at 1.8 hectares. And others in Vintners Lane, established 30 plus years ago, clearly indicate the suitability of the Vintners Lane soils and climatic characteristics for viticulture. And so we just wanted to reinforce that by way of appearing in front of the committee, supporting our submissions, and therefore opposing the submission by Antilles Limited, who seeks to change the zoning to residential and to remove the Martinborough soils overlay. And if you're saying, well, just a moment ago, you were arguing for the removal of the overlay. Yes, I was, but they are clearly very different situations and propositions. As I said before, I think it'd be fanciful to think about Nelson's Road being developed for viticulture. It is certainly not fanciful at all because it's established to have viticulture in Vintners Lane. Thank you, that's it.
Thank you for making those points. That's important. The word I've written down is distinguishable.
Yep.
So that's
Gone.
Yeah.
Yes, but Alistair's already said it very well. Because a picture tells 1,000 words. If you've got Miss Antilles vineyard up, I could show you. Can you be so kind? My point is that Mr. Antilles is just surrounded by vineyards, some of which are mine.
Can you just orientate us there a bit? Yes.
Look at this carefully myself.
Where we are in Martinborough, so are we?
I'll zoom out to start with if that helps.
Yeah.
So people can see the square.
There's a square, you're out.
Like a video game, which I never played. Basically, just stop
This is how it was cemetery.
Have a swimming pool, John, point the swimming pool.
Yeah,
You can see that.
I can see it, yeah.
Right,
Campground,
it's a swimming pool, isn't
Yeah.
it? Right, okay. That's the campground.
yeah.
This is where Mr. Abu lives.
Yeah,
Yes.
What I've done, that's where Mr. Abu lives, and that's his vineyard.
Yeah.
And that's where Silly old Mr. Porter lives, and that's his vineyard, one of them. And this is Antilles here.
Right.
Okay,
Gotcha.
and up here is Mr. Porter's other vineyard, which was planted in 94. And across here is the start of the Palliser Plishman vineyard, which goes all the way around here. And here, this is Mr. Antilles here. Over here, this is these are vineyards. This is Malwaka, and that's another little vineyard. So the point is that Mr. Antilles is surrounded by vineyards.
Yes.
And I may be so bold, we're pretty successful. We've been here 30 years nearly, and we're still here and making wine and selling it to sometimes all corners of the globe.
So what's on the block next to your long thin block?
Oh, next to my long thin block here.
Yeah, so closer to the main road.
So the main road's up there.
Yeah, so what's that block where your finger is now?
That's up there is the Nawaka.
No, go, those two blocks right there,
Yeah, put your finger on
where your shadow is.
Right, that is Antilles.
Yeah.
And that's the front part is Malnex.
Yeah.
So it's just a vacant field,
Okay,
which he's trying to sell me for grapes. So
that's,
is it suitable?
it's highly suitable.
Yes. It is a
Without Alice to accept the price.
thank you, Mr. Gordon. Mr. David, thank you for coordinating the presentations. You've used your time wisely, 4 minutes to spare. So.
We started a wee bit early. That's good.
So thank you. We'll be in touch in relation to that minute directly. Thank you, everyone.
Thank you. Nice appearing here in front of the Supreme Court, I'll tell you that.
Yeah.
Much friendlier.
Much friendlier. No.
Oh, I've never been there.
Thank you very much.
We got one via team.
That's the long corporate.
No, that's it. They're on by team, but.
Oh, yeah.
7 years.
Next one's on Teams, is it, David?
Yes, it is.
We got,
No.
yes.
It's real. Yeah.
Sorry, my stuff. Hold up. Hey. Right, good afternoon. Welcome to the next submitter, which is Eastleigh Limited. We have Mr. Josh Marshall and Christine Foster online. Welcome, both of you.
Good afternoon.
Good afternoon. We're right on time, actually, which not too bad, not too shabby an effort. So I don't know whether you've been listening in during this morning. We've heard from the 42A officer this morning, and we've got through all of his material. He has some homework to prepare for his right of reply, and we've just heard from the first three submitters represented by a common witness. So we're now on to our second witness for the day, submitter for the day, and that's Eastleigh. So we're in your hands. Who's going to lead off? Is that you, Mr. Marshall?
Thank you, Mr. Chairperson. Yes, so I don't intend to speak very long. I'll mainly be handing over to Ms. Foster, but just beforehand, I just want to make two quick points. In terms of the definition of highly productive land, now there's been a few drafts going around. You might recall from hearing stream 1, I made the submission point about the practice of referring to higher order documents within definitions and how in general that, in my view, that's not a generally good practice. I note in this case, however, with the proposed amendments, it leaves the definition referring to clauses 3.4 and 3.5 of the MPS without actually specifying what it is referring to. So I believe in this case, actually, we do need a reference to the national policy statement so it's clear what mapping exercise they're actually talking about there. So quite a technical point there, but just make sure we don't have any orphaned references.
Yes. Mr. Marshall, does that reference need to be time-stamped?
Technically not. For practice points, I think it'll be useful though, given the point I made previously that everything essentially is locked in time.
Yes, just picking up on a point that you made at an earlier hearing in relation to the need to timestamp or not timestamp.
Yes.
Okay.
Yeah, I guess my views on that are neutral. I don't have a particular view there because it is here referring to a process, you know, the part of the clause. So I think just reference to the MPS would be enough, but timestamp, you know, would potentially be helpful.
Well, sorry, just before we go off that, just so that I'm clear, that's reference to clauses 3.4 and 3.5 in particular. Is that what you're saying?
Yes, because otherwise there's no indication of what the definition is actually referring to.
Okay. Thank you.
The second point I make is just a procedural point. Just want to sort of highlight here. Ms. Foster, in her evidence, has spoken about Eastleigh's sort of motivations here. We're talking about the company's land to the immediate west of Riversdale Beach, which has been partially subdivided, consented, and there's sort of a hierarchy of possible relief which could address the issues with the proposed, well, Eastleigh's perceived issues with the proposed plan there. The preferred outcome is a rezoning. Now, except that we're not at a rezoning hearing here today, that will need to be addressed at a future hearing. However, I note that if the panel is not minded to rezone when we come to that at a future hearing, then these alternative measures do need to be considered. And I'm just a little bit concerned to make sure that if the alternatives are not going to be considered at the next hearing, then they should be considered here in terms of Ms. Foster's evidence, just so that they don't get left off the agenda entirely for these hearings.
Yes, that's a reasonable point.
Okay. With that, unless you have any specific questions for me, I might hand over to Ms. Foster now to speak to her evidence.
Thank you. Welcome, Ms. Foster.
Thank you, and good afternoon, everyone. Ngā mihi nui, kia koutou katoa. You have my evidence, and the issue is, as principally as the primary issues is summarised by Mr. Marshall, and it relates to the ultimate aspiration that Eastleigh has for its land, part of which is already developed as residential land, and part of which is proposed to be and has live subdivision and development consents, yet is zoned, proposed to be zoned general rural zone under the proposed district plan. So the question of the zoning needs to land at, I think it's hearing stream 13.
Correct.
Yes, and just because Eastleigh couldn't couldn't support the general rural zoning and had to, within its submissions, make points about the inappropriateness of the general rural zoning. That's why that aspect of it lands. But the real purpose of the submissions is to achieve a residential or settlement zoning and a mixture of, actually, because there's also public land or will be public land within that open space to reflect the reality of what is there. So it's a question of process, really, when Eastleigh is in your hands about the right way to go about that. But I can talk to you if you have questions, for example, about the alternatives to rezoning that I've presented in my evidence at paragraph 5.8. I've said this, if that's the aspiration, there's a couple of alternative ways of achieving that. One is a carve out specifically for these parcels of land at Riversdale. The outcome achieved by doing that would be essentially the same as a rezoning. So I think on an efficiency and effectiveness argument, the rezoning is to be preferred. But I'm happy to answer questions about that if that's helpful to you.
It is. I'll just go back one step though, Ms. Foster, and just excuse my ignorance here, but can you just tell us how the partially developed land as residential actually occurred and over what time period?
Starting in 2004, a series of applications for subdivision and for the residential development of the land. Twin consents, because it's zoned rural, so the rural bulk and location standards would otherwise apply. So it has twin subdivision and development consents.
Yes. Okay, and multiple applications over a period of time?
Yes.
Yes. Okay. All under the operative
Yes.
Well, the previous operative plan.
Yes. It might have been right on the cusp in about 2004, but there was not a lot of change in principle to the subdivision approach between the plans. Yeah.
Okay. Any regional consents granted?
Yes, there are, because the original subdivision consent, which was the largest of them for the terraces as a whole, and subsequent subdivisions have been for alterations and variations within the overall. The larger one proposed a wastewater treatment plant and discharge to land that became Riversdale's wider wastewater treatment plant. So yes, there are. There's also stormwater discharge consents.
Yes. And what sort of existing and anticipated yield is there at the moment?
Gosh, the numbers.
Yes.
Josh, you might have to help me with that. We could probably
I'm sorry,
supply
I
a
don't
plan,
have those numbers
which
to
would
hand.
be a plan would be more helpful, prepared by Adamson Shaw, actually, that shows you what has been applied for, what has been developed, and what is yet to be developed but is consented. That might be the most meaningful way of summarising that for you, rather than my unreliable memory.
Yes. Where would we find that? Are you saying that that's in the bundle somewhere, or that it needs to be provided?
I don't think it's in the bundle. It's not in the bundle, but we can supply that to you if it's helpful.
That's something we could prepare and supply after this if the panel would find it helpful.
I certainly would. I'm the only non-Wairarapa resident of these 9, so, and I must admit I've never been to Riversdale, so a site visit is on the cards.
It's always good to have a visual too.
Yeah,
so that would be great.
If you could provide that, that would be.
Yes, there is a version of it attached to the original submission.
Okay.
if you look to that, but we can provide it at a better scale. I think it's quite
Yeah.
puny when it's attached to that.
Yeah. Do you, I mean, just off the hand, have you got any feel for the quantum? Oh, right. Okay.
Oh, that's what you prepared earlier.
Do you want to describe?
Oh,
Does someone want to describe what we're seeing in front of us there on the screen?
Christine, maybe do you want to proceed with that?
Yes, so what you see is Riversdale Township. Can I take over the pointer, Ruth?
Should
Is
be able
that
to.
possible?
Yes, I'll get off. Or give control to you.
Yes, can you do that?
Not an option that's greyed out for some reason.
Not an option.
Is there an option on your computer to request taking control? Because I can't do it with request.
No, not without sharing. Okay, well, look, we'll try and do it without that. So there's the body of Riversdale Township on the right-hand side of the image, which has the urban scale allotment configuration, and then a sort of a line. And the line approximates the base of a coastal escarpment along the eastern seaboard of the Wairarapa. And above that escarpment is a series of terraces and gullies. The green parts of the image are gullies between flat-topped terraces, and the subdivision has proceeded in stages from the southern end with residential houses along a cul-de-sac, and then it's connected by a central road up to a middle terrace, and parts of which are also subdivided and developed, but not completely yet. And then it's separated by another green open space, and the northern terrace is subdivided, but not development of that has not yet commenced, but the consent remains live. So the green spaces have been planted, and the intention is that they are public open space ultimately. Yeah.
If I might just clarify one point there, the very northern terrace has not quite yet been subdivided in the sense of there are no titles issued yet.
It's a subdivision consent for it, I think.
It has been consented.
Yes. Yeah.
Look, that's a very effective verbal description, Ms. Foster. And we'll take you up on your offer of getting a better reproduction of that from Adamson Shore, I think you suggested.
Yes, I'm sure we have it on file, but this was an amalgam. The plan was attached to the submission, so I'll get something that's meaningfully shows you, I think, what you might be interested in, which is what has been consented, what has been developed, and how does that compare with the zoning that Eastleigh is requesting. Would that be helpful?
Very helpful.
Okay, thank you.
Ms. Foster, it's Alistair Fleming here. I remember when this was first muted and the southern part was done. My company was involved in it. How far to the west is the block of land going? Is it going further to the west than what's already there, or is what's seen on the western side of the three terraces, is that the furthest encroachment, or are you looking at further?
There are shown on this plan attached to the submission a couple of additions incurring into that western edge, but not in a large format, simply because the farm that remains works, and there's no intention to materially decrease the size of the farm. So the balance between the farming entity, Eastleigh, and this residential development has been settled, if you like, with this broad shape. I think if you look, the little areas that have white lines surrounding them are additional allotments.
So that's the future allotments.
Allotments, yes.
Yeah, that's on the northern part. Yeah.
Yeah, and to the very west of the middle terrace. Yeah. and a little boundary adjustment that has actually been consented already on the southern terrace. Yeah.
What we're not seeing there, Ms Foster, is that any legend or that pertains to the relief sought, but presumably that'll be clearer when we get the actual copy.
I'll attend to that, so it's as helpful as it can be, yes.
I mean, presumably the submission requested the area shown on Plan X to be rezoned.
It's quite specific, yes.
Yeah, from rural to, is it rural to residential or rural to settlement?
It's a mix of settlement zone and open space,
Okay,
covering the green patches.
yes.
Could I just ask why this is necessary if you've already got consents in place to actually carry on with this development? What's the end result that you're after here?
The end result is efficiency, so that the provisions that apply for people occupying and using these sites matches the actual land use, which is settlement, so that for example, the bulk of development restrictions aren't those of the rural zone, which has, very, very different standards, but that it reflects the residential reality. Yeah.
What size sections are these?
They vary. Some are as small as sort of 500 square metres, and the average of them are about 800. Some larger ones at about 1,000.
So it's largely residential size.
It's residential, that's right. So they warrant standards protecting amenity that relate to setback from boundaries, for example, and height provisions, and the requirements to connect to water supply, to have water supply, and to connect to the reticulated water system, etc. So it's a question of efficiency and reflecting reality, really. It somewhat defies belief that something that is actually developed as residential might be proposed as general rural in a plan.
I'm assuming, though, as part of what you've done here in developing, that all the sections are sold connected to the water system, connected to the sewage system, anyway that you put in place.
They all have individual harvested rainwater on site, but they are connected to the wastewater, yes.
Yeah.
Looking any further?
Just some more question. Is the rest of the village connected to that wastewater system?
Yes,
The existing village that was there? It is.
Yes.
yes now.
Thank you.
Yes. The main is connected through to what began as the East Lee wastewater treatment plant, but it is now Masterton owns and operates it. And I can't recall what process was undertaken to require that existing dwellings connect, but certainly the catchment for it is the whole of Riversdale. Yep.
Good. Thank you.
Just a couple of final questions from me, Ms Foster. Presumably there was no global land use consent appeared on lodge relating to departures from the bulk and location standards for the rural zone and applying the settlement zone.
There was a land use consent to develop the sections, that not so much as to be exempt from them, but to do a certain thing. And at the same time that the subdivision was proposed, the landowner developed a development guideline. So that covered things greater, more broad than perhaps the district plan would cover. So it was much more interventionist, if you like, in terms of what water tanks would look like, what colours could be used, where houses could be located, how high, how tall they can be. They're sort of 5 metre, 4.5 metre height limits on some of these to protect views from other properties within the neighbourhoods. So it's a lot more detailed, if you like, than a district plan would be. So the land use consent required compliance with that, and it picked up all of the bulk and location standards you have in the district plan, as well as a whole lot of other matters alongside. And each stage has taken the same approach.
Okay. The question is whether we need to see that now or whether we should wait until hearing stream 13 for that information, probably. I'm happy to wait unless you think there's some advantage in the panel seeing it at this point.
I'm in your hands really about that, because it's when you want to digest it and consider it. I think it's part of a whole package.
Yes, I'd rather get it in totality, I think.
Yeah.
Yes.
That makes sense to me.
Yes. Now there are other parts to your evidence that you're going to present on, but before you leave this matter, the alternative, which you've referred to as a carve out, was that largely a policy carve out that you were referring to?
It would require a policy carve out, and I've given some examples. I don't think the submission goes into sufficient detail, if you like, about exactly what the rules would be. The submission has addressed a number of the rules that would need to be changed, but hasn't specifically said in what way. So I think there is scope there to do it, but I have talked about for example, the submission addresses policy SUB subdivision P6, which is about avoiding inappropriate subdivision in the general rural zone. And it had a particular way, it suggested a way of resolving this or providing the carve out. My view is that some slightly different wording is required, and I've suggested that to you in my paragraph 5.8 of my statement. In fact, there would also probably need to be a matching policy carve out in policy GRUZ P4, and Eastleigh's submission does not directly address policy GRUZ P4.
Yeah. Okay. I guess the reason I asked the question is whether, if we deferred this matter to hearing stream 13, whether this would still be a live issue for that as an alternative, or whether we need to make a finding on that in advance.
I think I would have difficulty making a finding on it in your position without both of those in a section 32 sense being on the page.
Yeah.
So I think one is, in my view, one is an inferior way of achieving the same outcome. Yeah. And the zoning is the planning response, the appropriate planning response, I think, to the matter. But it would be possibly premature to make a finding on the carve out without understanding what the alternative is.
Sure. I expressed that pretty poorly, actually. What I meant to say was, would you feel disadvantaged if this matter was deferred in totality to hearing stream 13, and you spoke to both options then? Is that?
It makes a lot of sense, Mr. Chairman, and the issue that Eastleigh really wanted to raise was getting confidence that it would be considered in the round comprehensively. Yeah, and it's just the slicing and dicing of the hearing streams makes that difficult for you, but you have the power.
Nice to hear. Okay, well, we will do that. I think the panel's in agreement that it's best considered in totality at 13, and we'll do that.
That's reassuring. Thank you.
Okay. Now, do you want to, there's two other matters, the extended definition of HPL and some of the text in the introduction to the subdivision matter, and the highly productive overlay itself.
Yes, I could rattle through a brief summary. The very potted summary is to say that Mr. Horrell's recommendations and my evidence are completely aligned on all of those other matters now, with the added point that was clarified in Mr. Marshall's legal submissions that Eastleigh is not pursuing the highly productive land overlay mapping issue. But in every other respect, bar the ultimate rezoning request, Mr. Horrell and I, there are no issues outstanding between Mr. Horrell and myself.
What we'd like to hear for that.
Process works, sir.
On that note.
No further questions. We will we'll see you both back in probably April, May next year, if not before, on other matters.
Yes, I'm scheduled to appear later this afternoon from
That's
Meridian,
right.
but only if you have questions. I will be available if you do.
Well,
Thank you.
thank you. Thank you both.
Thank you very much.
It's not just this. Let's go here.
Questions, go timetable.
Oh, right, yes.
Table.
And good afternoon.
Hello.
So we've got the South Wairarapa Whenua Advisory Group, Mr. Isaac and Miss Greathead. Welcome. Thank you for coming a little bit earlier. We're running slightly behind time. We're in your hands. We've got a copy of your submission on the other. Do you have any further information that you're going to present in writing, or is it verbal?
We have in mind to give a verbal summation of the developments that have been so remarkable in the sphere of these solar plants. Where one appears, they quickly multiply. So as you have heard, there is some added information we'd like to deliver.
Are you going to be reading from a prepared statement, are you?
I'm just going to be looking at some notes, that's all. It is short and brief and to the point.
How would you feel comfortable in making those notes available after your presentation? Just to.
Yes, I'd be more than happy. I've only got one copy with me, but for what they're worth, and Jill will then.
We could get them emailed to Ruth.
Yep.
Just
we'll do.
Helps us to focus on what you're saying rather than trying to record what you're saying.
A very good aspect. We will do that immediately afterwards. We'll send you the copy of.
Thank you. We're in your hands.
Okay. Just to put us in context, it's now almost a year since our original submission, and large-scale solar installations under the consent process. So we got particularly originally north, and then this materialised into the one mooted, both based on the Greytown substation and then the one by Helios Energy, reliant on the same transmission line. In total now we find 6 solar installations planned for the area under the combined district plan you are undergoing at the moment. Over 3,000 acres, dramatic and indeed drastic and radical alteration to land use, the umbrella topic here. This is just the beginning, I sense. Now, in our original proposals, we stressed that these are proposals that fall into the hazardous activity category, and we still recommend that these are non-complying activities. Now that the scope of these installations is becoming clear, it is appropriate now to go into the radical effect that they have on the land use in the territory covered by this plan. There is a curious inversion here, and I may stress that people don't want to talk about this. It is politically sensitive, it is ideologically sensitive, but it has and will have intensely practical outcomes for the area under discussion now. And it is a curious inversion that as the value decreases for the investors in this plan, the liability component increases for the neighbourhood. Part of the problems here is that people don't want to discuss it, and we all know why, but the original value of these plants is contained in the original consent. Now, on the original court hearing, we had I asked the promoter, Mr. Homewood, are these consents transferable? And somewhat to my surprise, he was very candid and said, yes, they are. Now, it is in that consent and its value in the international market that is the value, because, as you know, the offset allows someone somewhere else to do something else. So I wanted to stress that because I wanted to put in context reasons why we do have this proliferation of these plants. It's time to look at the offsets career in this country, and we look at the timber offset country. For many years, I was associated with Napier Engineering, and I used to visit Napier a lot on the whole of the Hawke's Bay, and I would remark, why are all these tree stumps and roots on the beach? And everybody said, oh, that's the logging. You don't have to worry about that. And because I wanted to believe there was nothing to worry about, I didn't. And I perceive a similar state of affairs in the radical solar development gold rush, my description, but the head of Transplows that we have under consider now. The location, and I understand the complexity of soil types. We're talking about high yield types on the valley floor. And the reason they are so in demand is because, having been substantially knocked back from Australia with its more arid and desert-like territory where these installations are supposed to go, they have arrived literally on our doorstep because of the ease of installation and the convenience, and most of all in the flat land in this valley floor. They are also aware that obstacles are not in place here. It is one of the reasons that our pending second court hearing at the Copthorne is of value, because it will represent a landmark case in terms of the planning court's view on these installations. So you can imagine we're taking it very seriously. For instance, to give you an example of this, in South Australia, you cannot construct a large electromechanical chemical installation, which we're talking about here under solar farms. You cannot within 2 kilometres of a township, yet the one suggested by Helios will be within stone's throw not only of the township, but of a hospital and a school. And I don't say that pejoratively. I merely mention it to show that the underpinning planning and preparation is still very abstract. We're told that the leases are approximately 35 years. We're told also that the lifespan of the solar equipment is approximately 20 to 30 years. So I'll come back to my original point about this inverse. As the value decreases to the investors, i.e. the consent is running out, it's evaporating, it's like a tank of gas, it's running out, so the problem becomes more accentuated to the neighbours. Now, some of you doubt that and may say to yourself, this is a conservative viewpoint. And as I said in my original submission, I may counsel you to look at the activist film producer Michael Moore, The Planet of the Humans, who shows a major problem now in entities simply walking away and leaving these structures once they are exhausted. There's also the issue, which is not covered, of batteries, and everybody is extremely reticent on this point of batteries. The fact is, without batteries, these solar farms have little value, being only at productive level between 10 o'clock in the morning and 2 or 3 in the afternoon. So we're finding, as a concomitant of these installations, we will find separate battery farms. And also not widely are the inverters, currency converters, and the transformers, and the SCADA and control installations, which will be in ISO containers. So we have to look here, as this is a developing tourist area, we must, however fanciful it may seem, consider the impact on tourism. I won't bed you down here in the endless detail attendant upon landscaping, which the promoters are devoting so much time to. I can only note that if these things aren't an eyesore, why is so much attention being to hiding them from the public? So I mention that in the context of the Valley's tourist industry. I also note too that promoters insist that this is of low value land. This is, as you'll have done in your previous ruminations, demonstrated how contentious this is. Another point skated over, nobody wants to talk about it, is the lack of financial guarantees, sureties, bonds. These organisations are arranged around a corporate structure, which is of course designed to minimise risk. We have been unable in numerous interrogations and discussions to evaluate if a surety or a bond will be placed. If, as is very likely, the consent changes hand, will those terms and conditions on the bond be taken up? And similarly, not pursued is the issue of insurance. And we think there of the fire risk that has been gone over considerably in these matters, and the flood risk. We're told by very reliable sources, all government agencies, that the climate is changing, that it is evolving into extremes. And if the extremes are indeed heading this way, there will be few installations more prone than these solar ones. I might also state that this is different from any other building. Might be putting up a wool store, a fertilizer plant. They are single application only. If somebody doesn't want their use, will be restricted to another electrical operator, and with diminishing consent times, this too will diminish over the years and become less. Now, I was intrigued just listening to the Martinborough wine people and to look at their reports that there was no issue of contamination. Now, we are looking here at thousands and thousands of metallic piles being driven into what the promoters say is stony ground. This means there will be shards, there will be shavings, there will be scrapings coming off them. And the effect that these will have, and this is not including the equipment itself, which, according to much research, is very largely based on polyfluoroalkylate metallics, sometimes known as everlasting chemicals because of a curious chemical tendency. They have to bind, hang around for ages and ages and for generations. This is not discussed, and I would like to alert, if anybody from the Martinborough terroir is here, that particularly with the intense competition to keep out foreign wine, notably New Zealand wine, that if there is a perceived contamination of their terroir, it will be used against them. So that is my small lesson today. We come back to the problems of what if we're looking at the longest extended lease, which is 35 years. What if the end operator is unable to remediate, which has happened in America, the land, it will be left? What if the original leaseor, the farmer, or something happens to him, his family, he is not in a position, the conditions aren't transferred, are indeed the conditions transferable, is not in a position to remediate this land, which will have lying on top of it thousands of tons of electrochemical equipment. Now, I hope there I've given you a bit of background of what the SWAG organisation is seeking to draw, most notably folks such as yourselves, attention to in this extraordinary development.
Thank you, Mr. Isaac. Ms. Gray, did you want to add to that in any?
No, he's
Okay.
Yep.
Okay. I'll just see whether there's any questions from the panel to my left. Okay. And to my right.
All right, thank you.
I've got a couple of questions. The advisory group, South Wairarapa and Whenua Advisory Group, what can you tell me about that organisation? Is it a incorporated society? How does
It is incorporated.
Incorporated?
Incorporated, yes.
And it has a membership
It does.
and annual meetings and minutes.
It does. It conforms to the requirements of the Registrar of Incorporated Societies.
And what's the mission or vision statement for the advisory group?
It's to do precisely what we're doing now, draw people's attention to something that a very large sector of the community doesn't want attention drawn to.
Thank you. And finally, Mr. Isaac, what's the decision that you wish this panel to make in relation to the submission of the advisory group?
Our mission is to point out that the Wairarapa, which contributes so substantially to New Zealand's food exports, which account for 82% of the nation's wealth, does not have the short, medium, and above all, the long-term impacts inherent in having placed over pasture an electromechanical chemical plant.
Okay. In other words, what changes to the plan as notified would your submission require us to make?
It, as we noted, that this is a hazardous activity, as we say, and that it is quickly and perceptibly defined as a non-complying activity. We might almost say, and I understand this isn't the terminology, an experimental category.
In the rural chapter, I mean, I notice in your submission you actually don't mention any specific objectives or policies or standards or rules. Sorry, I'm just having a quick reread. Can you point us to which area of the chapter that you're actually specifically referring to that we can easily access and cross-reference?
I could maybe assist with that. So it was an inferred decision for the protection of rural land, which relates to the rural topic. But largely it's related as
Energy network.
That's right.
Yeah.
I may fill out that with some background, and thank you for that input. We are concerned about it because when we set this up, and let me give you an example, I was about the fourth chairman point chosen because I have no job, and I had no job at the time, and not one pending, and I was considered ungettable at. Everybody else backed down, we're going to get into trouble here, and particularly with the corporate and government employment, that is a perfectly understandable view, and I would have shared that view had I been in their position. But such is the hysteria attendant upon this type of technology, and I may notice that New Zealand is now, and for a while, overtook Iceland as the world's latest user of renewable energy, 93%. It is recognised, curiously enough, by the International Energy Agency as the world leader in renewable energy. So, as I particularly looked at the position, having had a lot to do with the Valley for 65 years, and particularly in its productivity, I sensed that the people who have retired here seeking tranquility and about to have their lives very much upset needed a spokesman for the organisation and put it into the context of New Zealand's already leading use of renewables, notably, which is also, and I have to point out here that it is an extraordinary example of this country's triumphs, deliberately obscured because politicians, and I include a lot of them here, are terrified if they say we're doing so well, they will be accused of dragging the chain and will lose their key metropolitan inner city professional managerial class votes.
Yes,
Sorry about that.
It's okay. I just need to check with Mr. Horrell. So this is an inferred submission for the protection of rural land.
Yes,
And the main relief that will be sought will be expressed in the network and energy chapter.
that's right. Yes.
That's good. Understood that. Thank you for your presentation.
Thank you for inviting us and listening to us.
You could email that through to.
We will.
How do we want to break our afternoon tea or hear from some of the?
Break and bring that call you there.
Yeah, it's a break.
Yeah.
Mr. Ensor, are you online?
Yes, I am.
Mr. Ensor, the committee feels that they need a bit of a break. We might break for 15 minutes for a tea and come back at 3:30 if that's okay with you.
Completely understandable.
Okay, we'll see you then.
Thank you.